Okay, I want to now officially welcome everyone to this Free State Foundation event. And of course, FCC Commissioner Brendan Carr is our featured speaker. This event is a part of our 13th annual Free State Foundation Policy Conference. When we did our event last week with the two FTC commissioners, when I said it, the 13th annual uh, policy conference, I stopped myself and I said, wow, because I said every time I think of that, the 13th annual conference, I do say wow. And also pointed out that it's our 15th anniversary year in June. We'll be celebrating our 15th anniversary. And also said, short of being thrown in jail, that one way or another, I'm going to find a way for us to celebrate together in person. If not in June, then sometimes this year. And of course, I hope that Commissioner Carr will be with us then when we do that. Okay, what I'm going to do now, I'm going to introduce Commissioner Carr, and with us today, you'll see Seth Cooper. Seth is Director of Policy Studies and a Senior Fellow at the Free State Foundation. And I know most of the attendees today are familiar with Seth's work and his prodigious output and his contributions to the Free State Foundation. So I'm not going to say more about Seth, except that I'm pleased that he's going to be joining me in the questions today. Now, for Commissioner Brendan Carr, first thing that I'll say is I believe, Commissioner Carr, you've updated or revamped your bio on the FCC website a little bit. It had a little bit of a different look since the last time I had a chance to introduce you. Anyway, and welcome back, because we've been pleased to have you with us many times in the past, and it's always a pleasure and indeed an honor. So one way it's been revamped, it begins by pointing out that Commissioner Carr is the senior Republican on the FCC. And he also served previously as the agency's general counsel. So if we put him on the spot today with any questions that have law as part of the background, then that's our prerogative. He's been general counsel. Now, it says on the website that Commissioner Carr has been described by Axios as, quote, the FCC's 5G crusader. Carr has led the FCC's work to modernize its infrastructure rules and accelerate the build out of high-speed networks. His reforms cut billions of dollars in red tape, enabled the private sector to construct high-speed networks in communities across the country, and extended America's global leadership in 5G. Now, as many of you know, unless I know these things to be true, then I don't just read them off someone's bio. So I know that statement to be true. I didn't know about the Axios label, but that's certainly true. Just to pick out a couple of other things, it also says that Commissioner Carr leads a groundbreaking telehealth initiative at the FCC and has been focused on expanding America's skilled workforce, especially relating to tower construction and other infrastructure things. And I know those things to be true as well. Now, Commissioner Carr was nominated to the commission by President Trump and confirmed unanimously by the U.S. Senate. When we last Friday, when I was introducing FTC Commissioner Christine Wilson, I pointed out that she had been confirmed unanimously. And I think it was Commissioner Wilson, or perhaps it was Commissioner Phillips. I don't want to misspeak, but in any case, that doesn't happen that much anymore in today's environment. So that's noteworthy as well. Commissioner Carr, just tell everyone when your term expires, your latest term.
Yeah, my current term goes through June of 2023, I believe. So I've got a couple years left and really looking forward to continue to serve here.
Terrific. Okay, now before we get into the questioning, I just want to remind everyone to please tweet if you're inclined. We happy to have you do that. It's hashtag FSF CONF 13. FSF CONF 13. So please tweet away. Okay, we're going to go ahead and dig right in. We've got a lot to cover today and want to get to a variety of topics, but I want to begin this way. Commissioner Carr, you've been now operating for a couple of months in this new environment in which there's a 2-2 split at the commission. You know, I think if you're honest about it, you would probably admit that it's nicer to be in the majority if you had your druthers, or maybe not, but in any event, now you're operating in a much different environment. So tell us how you think things are working out under the present arrangement. Maybe I can just add to that question. I mentioned some of the areas that you've been a leader on, or took the laboring oar previously with infrastructure and so forth. And do you have any indication so far in your discussions with Acting Chair Rosenworcel that you'll be able to continue to take the lead on those issues? So why don't you start off with that, please?
Yeah, well, thank you so much, Randy, Seth, the whole team. I always really enjoy these conferences. It's an opportunity to, I think, elevate our discussion a little bit above the usual Twitter level conversation. And I've been known to scrum it up a little bit on Twitter myself, and it's kind of its own approach, its own language to issues. And I think this is a great opportunity to step back, take a little bit more time with issues, and engage in sort of the really sort of more academic discussion that rightfully drives a lot of the policy. Short of being in the majority at the FCC, I got to say, things are going really well at the moment. I joined the FCC in 2012, so I've lived in various capacities and various hats under various compositions of the commission. And as we transitioned into this 2-2 world, if you remember, there were these sort of, doomsday, almost net neutrality, sky is falling predictions about how this would create deadlock at the FCC. And the reality is quite different. From the get-go, I got to give credit to Acting Chair Rosenworcel. She reached out, almost immediately on her designation, asked me, right away to do an event with her on telehealth, which is something that I've been focused on in past jobs. We did a joint event together. And really from that, a lot of conversations and compromises have flown from there. Right now on the 8th floor, I should say the 10th floor where I am now, we're engaging in a lot of give and take. We have voted on some big ticket items, 2-2. We got done on short order this emergency $3.2 billion emergency broadband benefit program. We moved forward on another 5G band in the 3.45 gigahertz. So some big ticket items. We didn't see eye to eye on all of the policy cuts there, but we did, I think, what the American public expect of us and what they probably think happens all the time at the FCC, which is we compromised. And I think the end result of our decisions have been improved by that compromise. So right now, things are going very well. There's a lot of give and take. I don't have the gavel. Elections have consequences, so I'm not pushing to get things that I can't get in this capacity. But we are finding common ground, and I think that has been all too rare at the FCC over the last couple of years.
Well, that's encouraging to hear, and we'll see what the future holds. But you mentioned net neutrality, and to be honest with you, we haven't had an event in the last well, maybe since we started back in 2006, where in one form or another net neutrality hasn't been a topic of discussion. So let's go ahead and just talk about that just a bit and get it out of the way if that's one way of putting it. But of course, it's important. So here's my question. Having in mind what you said about the 2-2 current split, let's just assume, for the sake of this question, that at some point there's going to be a 3-2 Democratic majority. So my question is this: Do you think that you can convince the Democrats not to resort back to Title II? And when I think of that question, I have in mind that we've now had 3 years of experience under the what we can call the Restoring Internet Freedom regime. I think, at least from my perspective, and others, there's some widespread agreement that the broadband ecosystem has been developing well. That we all know there's certain issues that remain and so forth, but the light touch regime, at least, and compared, for example, just say to Europe in the pandemic, we seem to perform well. But in looking ahead, how do you see this unfolding? And are there prospects that the new majority might be convinced not to go back to Title II?
Well, thanks for the question. If you step back and you go back in time to 2017, when we reversed our sort of 2-year detour with heavy-handed Title II regulation of the internet, put yourself back in that time and remember all of the, headline grabbing predictions about literally, quote, the end of the internet. And you would get tweets one word at a time, and the internet would slow down. And look at what we put in place was this light touch framework in cooperation with the Federal Trade Commission, where we had sort of heightened disclosure obligations backed by the FTC's Consumer Protection Authority. So consumers have been protected. And look at that internet layer and what has happened in terms of the incentives that our approach has resulted in. We have seen, on the infrastructure side alone, we went from 708 cell sites built in 2016 to over 46,000 cell sites built in 2019 alone. That's a 65-fold increase. Think about the families that are getting service from all of those new cell sites that when COVID hit, they were connected to the internet, not on the wrong side of the digital divide. Look at internet speeds. They've more than tripled over the last 4 years. That's a far cry from getting tweets one word at a time. And this is not just a natural progression of technology. If you look at the global mobile speed indexes, the US over that same period of time leapfrogged 20 other countries. And again, we saw this with COVID. That was the ultimate stress test of your country's approach to internet regulation. And the US networks, even though they saw a massive spike in demand, they continue to perform well and in fact outperformed countries that have heavier handed approaches. So the data that has come back is very clear. The approach that we adopted in 2017 is working. Speeds are up, prices are down, and we're seeing more competition for America's broadband dollars than ever before. So I think we need to maintain the approach that is working. Also, I think things are very different than they were in 2015, the last time we headed down this Title II approach. For one, a lot of people talk about net neutrality as this idea that all bits should be treated equally. And if you take that approach, the threat to a free and open internet, the threat to the manipulation of data and content, as data goes into, is not presented at the ISP level. What we're seeing right now in terms of threats to a free and open internet comes from what some people would describe as different layers or different portions of the stack. Whether you have infrastructure entities like AWS, whether you have edge providers. So I think if the theory of net neutrality is that we need to make sure that all data is treated equally, then we need a holistic approach that looks at that piece of data through its entire life cycle through the internet to make sure that there's not a threat to it anywhere along the route. So again, I think the approach that we're using is working. I think the data very clearly shows that. But if folks are hell-bent on going back to this Title II approach on a theory that we need to heavily regulate our way to make sure that the internet remains free and open, then the greatest threat is no longer the mom and pop ISP in Iowa. It's some of the largest companies in the world that are engaging in far different practices, let's just put it, when it comes to that bit of data than other portions of the internet ecosystem. And there's other things that are different as well. Congress passed the Privacy CRA in 2017, and that strips the FCC for all time of our authority to apply privacy regulations to the conduct of ISPs. If you reclassify the internet under Title II, that strips the Federal Trade Commission of its authority to police the privacy practices of ISPs. And now at the FCC, because of the Privacy CRA, we can't fill that donut hole. So you create a fairly arbitrary regime that leaves consumers less protected with respect to privacy than they are today. I also think there's some interesting, free speech, First Amendment issues that arise when you go down the approach of, Title II style net neutrality regulation. And so I think there's some risks on appeal, including up to the Supreme Court, if you were to try to go back to the FCC with this type of approach. That said, I think we can find common ground if the idea is, how do we get some basic rules of the road? Well, let's put rate regulation off the table and let's talk about what some common sense rules of the road would be. And I'd be open to those conversations.
Brendan, it seems to me you've got a lot to talk about with your colleagues.
Not that I feel strongly about this.
No, well, we feel strongly about it as well, and there's a lot there. And I think you got close to coming up to the issue that I want to talk about later and dig more deeply into content moderation and the market power of the companies that we now tend to call big tech. And I think what you were saying is that that's been another change since the last time the FCC dealt with this, and we'll talk about that. Before we leave net neutrality and move on to spectrum, let me just ask you this: the question of preemption of the state laws is with us. Of course, just recently after the litigation, the Restoring Internet Freedom litigation finally played out, and we got back to California and its own net neutrality law, which, by the way, in some respects is more stringent even than the Title II order from the Wheeler Commission, or at least arguably so. In any event, that's now being litigated. What do you believe the prospects are ultimately for federal preemption of these various state laws prevailing?
Well, preemption has been a core component of various FCC's approaches to net neutrality. Remember, the Wheeler era FCC had preemption in its Title II approach. When we went back to the light touch approach, I think it was pretty clear from that decision that we had sort of a preemption approach embedded in that. And I think it makes sense. Just look at some of the negative consequences you're seeing already that are flowing from the California style net neutrality. You've got wireless providers that are having to cancel free services. And, that does not seem like a very pro-consumer outcome. So I do think as we go forward at the federal level, it makes sense to have a uniform approach to the entire internet ecosystem, given the way that, these technologies function.
Are you optimistic that ultimately that will prevail? I mean, obviously Congress itself could do something, but short of that, are you optimistic or pessimistic about the litigation, or what do you think?
Well, if I was being sort of taking a skeptical approach to this, I would say that, it's all over but the yelling and the fundraising. But, I'm an eternal optimist, Randy, so I don't take that approach. I think if we can strip away, some of the political messaging associated with this, there is a tremendous amount of common ground with respect to non-Title II or respect to sort of non-rate regulation, net neutrality. And if what people really care about is, a permanent solution that's not going to ping pong back and forth, I think we can absolutely get there. Will people move off of their messaging positions and just sort of get to that core issue? It's hard to tell. I mean, I think the status quo is working tremendously well. Speeds are up, investments up, we're leapfrogging our global competitors. So from my perspective, there's no need to take any action. But for the interest of putting this behind us and, forestalling all the negative harms that would come from even the threat of rate regulation, I think we could very easily come together, put, some common sense, bright line rules in place, and move on from this issue, because, this is something we've been talking about since the early 2000s. It's a very backwards looking approach. Competition is solving a lot of the even hypothetical harms that some have espoused, and we should be looking forward. We have too much work to do to sort of finish closing the digital divide, to have so much of the oxygen in Washington at the FCC absorbed by this net neutrality debate. And if we head back down this path, just look at what's in front of us. We got this 3.2 billion EBB that we haven't stood up yet, that we have to stand up. We've got $7 billion that Congress gave us through E-rate. We've got RDOF phase 1 that we still haven't gotten any money out the door. We've got, billions of dollars we've set aside for RDOF 2. We've got billions of dollars set aside for the 5G fund. This is real work that's actually going to make a difference in the lives of American families by bringing them across the digital divide. We don't need to sit here and have sort of a, pinheaded discussion about the politics of net neutrality. If people care about the issue, fine. Let's get together. Let's put basic rules of the road in place that avoids all the harms of rate regulation. And then let's focus on what really matters, which is making sure that the services are getting built out, and that there's affordable internet options out there for Americans.
Okay, well, heeding that sound advice, what I'm going to do now is turn it over to Seth Cooper, and I think Seth's going to pose some questions to you about spectrum, and some of which relates to what you've just said, of course, Brendan. Seth?
Thanks, Randy. Commissioner Carr, I wonder if you could touch on what you consider to be some of the most viable near-term opportunities for getting new spectrum out there. You've made a lot of progress the last few years. You have great momentum. The commission just adopted an order on the 3.45 to 3.55 gigahertz band. What do you see as the best, near-term options to get more spectrum out, particularly for mid-band spectrum?
Well, the good news is we've got a tremendous amount of spectrum in the pipeline, and now we need to show sort of the fortitude and leadership to get it out. Again, sort of back in 2017, we were in a very different position. The prior FCC had voted on a lot of high band spectrum auctions prior to 2017. And so when we stepped in, we completed the work of that prior FCC of conducting the auctions that they had prioritized and that they had teed up. And then we moved and noticed that we had a lack of mid-band spectrum, including a lack of mid-band spectrum in the pipeline. And so we got to work pretty quickly. We held the first auction of mid-band in 2020 with 3.5 gigahertz, 2.5 gigahertz. We opened up that band to more intensive use and teed up about 100 megahertz of that for auction, which I've called for this year. At 4.9, we freed up some of the spectrum that was in a 50 megahertz swath. L-band, C-band was almost 280 megahertz of sought after mid-band. So we really got to work and pushed a lot of mid-band spectrum out there over the last couple of years. Going forward, what I've said is we should lay out a spectrum calendar And I've gone ahead and sort of filled in that calendar. I think this is how we can extend and maintain U.S. leadership. And so what I've called for in 2021, this year, is one, holding the auction of 3.45, which seems like we're well on the way to doing that, given our vote in the last week or so. I think we also should hold an auction this year for the 2.5 gigahertz spectrum. We've teed up the ability to do that through a PN earlier this year. And I also think on 6 gigahertz, we need to move forward with an order that opens that spectrum band up for VLP, very low power, which is really a key to unlocking a lot of the AR and VR use cases that's going to drive 5G. And I've also said that we should look at opening up the 3.5 gigahertz band to higher power use to extend the reach and utility of that band. I've gone on from there to identify some more bands that we should move on in 2022. And I've also offered ideas on bands that we can move on after 2022. So I put this spectrum calendar out there. And I think that those are the right priorities in terms of what we should be moving on when.
Yeah, I would commend your speech that you gave in that calendar to anyone. I think it's a really excellent overview and very helpful. And
thanks, I appreciate it. We put a lot into it. I was trying to avoid falling into the trap that sometimes you can fall into when you're outside the majority, which is to react to the majority or sort of vaguely call for actions in different directions without putting out an affirmative agenda. So early in my shift from majority to on my way to the minority here, I wanted to put out what my sort of affirmative ideas and thoughts would be, and that way we can all sort of work off of that to the extent my colleagues agree.
Yeah, and if I could say, I thought that was one of the things that I like best about it. I thought that was kind of a model for both appointed and elected officials who may not be in the majority, rather than simply wait. And we've encountered this before with officials who'll say, well, we just need to wait to see what the majority has to say and what they're going to do. There's no reason you can't simply make good constructive proposals and then see what can be worked out. So now looking at that calendar and that list of spectrum, a lot of that seems to involve spectrum currently used by federal users, federal agencies. Are you hopeful that you can get cooperation from some of these agencies, particularly the Department of Defense, in getting that spectrum shared or getting it cleared?
One of the things I talked about in that speech was where we are right now in terms of spectrum policy in this country. At the end of the day, I think we saw this over the last 4 years, freeing up more spectrum for American consumers, spectrum that is tied up in the hands of sort of federal users, requires FCC leadership that accumulates political capital and shows the willingness to spend it. We do a lot of coordination. We do a lot of meetings. It's great to further formalize those and deepen those. The challenges we had with freeing up spectrum was not a lack of communication. It wasn't, being short one MOU. It was, incumbency. And federal users are very focused on their mission, rightly so. And, if freeing up spectrum is going to pinch them in any way in their mission, oftentimes they're going to dig in. And that's because they're trying to achieve what they've been directed by Congress or by cabinet officials to achieve. I get it. At the FCC, we have to step back and look at the public interest, both in achieving those core federal missions. How can we best achieve those? And how do we best make sure that the American economy stays competitive? So at the end of the day, there's going to be disagreements. We saw that whether it was 5.9 gigahertz with DOT, whether in the millimeter wave spectrum with NOAA, whether it was with DOD on Legato and the L-band. And in every case, we looked at the engineering, we looked at the analysis, and we had the willingness at the end of the day to make the tough calls and move forward. There was no amount of additional, conversations or discussions that was going to, shed any additional light on the issues. They were fully vetted, fully discussed, and we had to move forward. So I think the key is to make sure that we continue to show that type of strong leadership. And I think 5.9 gigahertz is going to be one of the first tests. It's very important that I think that all of us at the FCC, Republican, Democrat alike, speak out as we're seeing increased calls, whether on Congress or through new leadership at DOT, to try to get the FCC to retreat on its decision to free up a significant amount of that spectrum in 5.9. So I don't think the FCC should move backwards on that. I think we should all send a clear message about that probably pretty quickly here.
Okay. Now, Commissioner Carr, I want to ask you about spectrum screen in a second, but really quickly, do you have any ideas of structural or procedural reforms that could improve the interagency process for government spectrum and getting that moved over to commercial use?
I think there's always more steps you can take. But again, at the end of the day, the challenges that we have seen were not the product of a lack of coordination or a lack of communications or a lack of exchange of ideas. They were sort of disagreements that we at the FCC at the end of the day are charged with calling the ball on. If you look at some of the headline level controversies, if you want to call that, between the FCC and federal users over the last couple of years, it wasn't because our approach was different. It's because that we followed through. There were a lot of spectrum bands, whether it was 5.9, Legato, that past FCC leadership took a pass on because they knew that it would produce those types of headline level controversies. But we made the right calls. And so I think that's going to be the key going forward, is to continue to make the right decisions, even if it's going to result in some negative press headlines.
All right. Well, on spectrum, going from all the other federal agencies outside the FCC to something that's very much in the FCC, and that's the issue of spectrum screens. That is something that's been there in the past. The idea that there would be some kind of commission-imposed limit on how much spectrum that a particular wireless carrier can license in a particular band all over, or divided up in certain geographic ways. What's your take on spectrum screens and their viability and what's next?
Our current approach to spectrum aggregation and spectrum screens, I think it increasingly is clear that it is failing what I've talked about before in spectrum speeches as the Gretzky test, which is, famously the line, you need to skate where the puck is going, not where it is right now. And our entire approach to spectrum screens and spectrum aggregations, it's a 1G, 2G approach to a 5G world. It fails to understand the upgrade in technology and the upgrade in competition that has come with 5G. And I'll give you this an example. Right now, T-Mobile in the last week or so has announced that they are going to have something like 7 to 8 million in-home broadband subscribers. Verizon has similarly said that they are going to cover something like 50 million homes. This new competition, wireless, historically mobile wireless, competing in the fixed broadband game, competing with fiber providers and cable providers for in-home, that is a type of convergence, a type of competition that our spectrum screens were never intended to apply in a world like that. Our spectrum screens are stuck in this mentality that mobile wireless competes against mobile wireless in a steel stovepipe. And what we have gone to, particularly with 5G, is this concept of convergence. Wireless is competing with cable. Cable is competing with wireless. Broadcast now has the potential with 3.0 technologies to compete with all of them. Fixed wireless providers are entering the game. So we have this scope and scale and type of convergence where previously distinct competitors are competing hammer and tong to take broadband subscribers from each other. So I think, I've talked about this at length before, we should redefine our approach and look at connectivity in general. So sort of laying that groundwork, when you look back at the spectrum screen and spectrum aggregation, we're saying we're going to take one piece of one set of competitors in this broader market for connectivity, and we're going to apply to them a technology specific limit on their capacity, which is spectrum. I think we've made this challenge worse recently because in 3.45, we're now applying an upfront limit on the spectrum you can purchase at an auction, while then continuing to maintain this back-end spectrum screen. And our back-end spectrum screen is weighted in very odd ways. We give heavy weight to low band based on the 600 megahertz auction when people were saying that was beachfront spectrum. Now technology has moved on and people say, mid-band is the new beachfront. Well, our screen doesn't reflect that. So all of that is to say, I think our current approach suffers in ways that if we were to attempt to apply it and get pushed by industry, I would have a hard time seeing our approach withstanding review under sort of a basic arbitrary and capricious approach. It's sort of an artificial constraint just on one sector, mobile wireless, that you don't have against their competitors. And what's also odd to me is, you look right now, there's a lot of talk in Congress in particular about upping our requirements for speeds and defining, broadband speeds a lot higher. Well, it is inconsistent to say on the one hand, we need 100 megabit service from wireless and fixed alike to qualify for, broadband. At the same time, we're applying these spectrum screens that are a constraint on the ability to offer those high-speed services, because spectrum and capacity is key to delivering those speeds. So on the one hand, we're jumping on the brake while demanding that the car goes faster. And so I think, summing all that up, we need to bring some fresh thinking here and look at the entire market for connectivity and not apply this, very sort of 1G stovepiped approach to spectrum aggregation.
Commissioner Carr, it's probably not appropriate to toot our own horns here, but I will say that we have been saying here at the Free State Foundation a lot of what you have just said very eloquently for the last maybe 4 or 5 years. We didn't get the commission, even the last commission, to agree with us really in terms of looking at the market, the broadband market, in a way that included.
I did not win in convincing the past FCC either that this is the right way to look at it. So we're on the same side of that one.
No, I know. Well, maybe together now we'll have maybe some luck in the future, but thanks for that. So what I want to do now is I want to ask you a little bit about some of this we may have touched on, but it'll be a chance to add, if it's appropriate, about infrastructure siting and just broadband deployment. And then I'm going to turn to, after that, social media regulation, which I want to make sure we get to. And I want to tell our attendees that, in about 10 minutes, I'm going to invite attendees to put questions in the chat room, and I'll be able to look at them. And if we have a few minutes, I'm hopeful Commissioner Carr will take a few of those as well. So, Brendan, on infrastructure siting, if we put that sort of in a box, and of course that's part of broadband deployment, but you were a real leader in addressing, I started to say attacking, but I think addressing some of the impediments that needed to be tackled at the local level in order to speed 5G deployment. And so I want you to tell us about any further actions there that you think should be taken. And then just go ahead, and while you're talking about that, there are all these and you just alluded to some of it when you talked about the new broadband standard, I think, that's being proposed in one of the bills on the Hill, the 100 up, 100 down. But there's a lot of money. There's a lot of money that's being talked about for broadband deployment. And of course, to close the digital divide, I'm sure that some of that is necessary and appropriate. But talk to us about your thoughts on broadband deployment now, further actions needed, and within that, if there are more of the siting types of things that you were so involved in, about any actions there that are still needed as well.
Well, thanks. I mean, again, if you look back in 2016, the experts and analysts were not painting a very rosy picture of the US's future leadership in 5G. And one of the key reasons that they pointed out back then, Deloitte and others, was that it cost too much and it took too long to build out internet infrastructure in this country. And they were right. If you look at the data, new tower builds had effectively flatlined in the run up to 2017. And the reforms that we put in place helped flip that. I talked about how we went from 708 new cell sites in 2016 to over 46,000 in 2019. I mean, that is tremendous progress. And again, think about all the families when COVID hit that had no service before, but were pulled across the digital divide because of those builds. And not just towers, we saw it with fiber. We had a record-breaking level of new fiber builds, 450,000 route miles, enough to wrap around the earth 18 times just in 2019. Again, think about the resiliency that added to our networks, and the families that got coverage because of it. So I think the infrastructure reforms we did really helped to sort of pave the way for the private sector to connect more Americans than ever before. And there's still some low-hanging fruit there. There's reforms we can do on the pole attachment side. There's a petition filed either last year or the year before that would ask us to start a rulemaking to do that. There are several, pretty basic steps we can do on the infrastructure side to build on the builds we've already seen. And this is not the time to sort of pull back or go backwards to a time at which internet builds were flatlining, particularly if, Congress is pushing all of this money out here to support builds. Then let's make sure that money goes into the ground, not into, additional red tape.
I know there is a proposal on the Hill. I think it's Representative Butterfield and others are behind it as well, to eliminate the ETC designation in terms of dispersing this money as a requirement that whatever purpose it had originally may not make sense in today's environment. What do you have thoughts on that yourself?
The ETC regime is sort of a hangover from legacy approaches. So I do think it merits Congress taking a look. From my perspective, I don't think there's a lot more we can do from the FCC side without some congressional changes to statutes. But I'm certainly open to those discussions taking place in Congress and making sure we have the right approach to consumer protection at the same time.
Okay. Seth, in a moment, I want to get to Commissioner Carr on social media regulation and Section 230. But if I know that you had a question, I think, about ORAN, and that's just recently one of those acronyms we've all become familiar with, and something the commission has begun to focus on. So if you want to pose a question to Commissioner Carr on that, why don't you do it now?
Sure. Commissioner Carr, do you see the FCC as having any affirmative policy actions or steps they can take to address Open RAN and promote American competition against communist China, and in terms of our infrastructure and getting us well set in 5G?
Yeah, I'm pretty excited about this shift to ORAN. It's part of this broader trend line we see in wireless and in internet connectivity generally towards unbundling. And if you look at the wireless industry, they've started to separate years ago from vertical integration. In some ways, first by shedding their tower businesses. Those are now sort of owned by third parties rather than vertically integrated within wireless companies. And that sort of trend is continuing to some extent with ORAN. And the basic idea there is separating hardware from software. And we saw that take place with the home PC market, right? So when Apple first came in, we're sort of back in the 90s at this point. They were sort of vertically integrated. It was the software, it was the hardware, and it was expensive. And a lot of families couldn't afford it. Well, Dell, Microsoft, IBM came in, Microsoft in particular, and said, look, I'm going to go after the software side of Apple's business, and I'm going to leave alone the hardware side. So Dell and IBM came in. And so when you separated hardware and software, you got better software, lower prices, more innovation. And that is the same type of dynamic we are expecting to see with ORAN. Right now, you've got sort of these single vendors, vertically integrated hardware, software. And in fact, many markets for wireless carriers are sort of single vendor markets because of a lack of operability between the network gear. So ORAN could help sort of make it so that we have higher performing software running on relatively less expensive hardware. A couple good things from that. One, it's more competition, particularly to vendors like Huawei or ZTE, because now when you're competing at the software level, you don't need 15 or 20 billion dollars from the communist regime to start up an R&D facility to manufacture bespoke pieces of equipment. You can just code and write your own software. It also plays to an enduring American strength. We have a lot of companies that are good in that space. So it's going to result in more competition. It's going to result in a more secure network. So we're optimistic about it, but I'm not putting a thumb on the scale. At the end of the day, it's going to come down to the private sector, making the best decision for itself about when, where, and how to go with O-RAN.
Okay, well, thank you for that. Just a couple housekeeping things while I'm thinking of them. I'm going to invite attendees, including reporters, of course, if they have questions they would like to have posed, they can put them in the chat, and we'll see whether we have a chance to pose a couple of those. The other thing I want to say, once in a while I'm asked about this. I'm going to ask Commissioner Carr to do me a favor here. I just want to be clear that I have always invited Commissioner Rosenworcel and Commissioner Starks to participate in our conferences and events as well. And I've done that again this year, as well as previous years. And, I'd be pleased to have them on. We like to discuss ideas from all vantage points, and even if they're not the ones at the Free State Foundation we espouse. So, Commissioner Carr, if you bump into either one of those commissioners over there at the new headquarters, just make sure they know. I think they do, but we would welcome having them participate as well. Okay, I want to turn to Section 230. That's and social media moderation issues, and that's something that you've been pretty outspoken about. And in fact, during last Friday's session with the two FTC commissioners, Commissioner Christine Wilson actually said that you had been a leader at the FCC on that issue. So what I'll do, I just want to read something that I dug up that you had said previously that I think captures maybe a way for you to have a chance to talk about it. And of course, earlier when we were discussing net neutrality, Commissioner Carr, you brought up yourself the power of what we call big tech, Google, Amazon, Twitter, and Apple, and so forth, and as well. So you have said, and I don't have the exact time here, but quote, a handful of corporations with state-like influence are not merely exercising market power, they are abusing dominant positions and taking advantage of a landscape that has been skewed by the government to favor their business models over that of their competitors. Now, I guess the question is, what do you think that the FCC should do about that, can do about it, and if not at the FCC, what can Congress do or should do to address these concerns that you have articulated over and over along the lines of the quote that I just read? And go ahead and have at it.
Well, thanks. I think our nation's public policy with respect to content moderation on the internet is failing. And I think it's failing in two directions, or failing in both directions. On the one hand, you've got illegal content that is staying up, and you have got core political speech that's staying down. Now, it's perfectly fair for people to say, as a sort of matter of first principles, that we want that decision to be left entirely to the private sector. And I am very sympathetic to that view. The challenge is this: with Section 230, the federal government has stepped in to that decision-making by inserting those provisions of law. And so if we are going to have law with respect to content moderation, I think we need to look, is the decision that were made in the 1990s working or not? And my view, as I have said repeatedly, as I said just now, is that it is failing in both directions. And I think that there are some targeted reforms that we can make that would produce, that would be an improvement over the status quo. So a lot of people talk about Section 230C1, which from my perspective basically says, if you're going to leave speech up on the internet, the speaker is liable to the extent that there is any liability associated with that speech, not the website. I think that makes a lot of sense. The challenge that I have is with Section 230C2. And again, there is a disagreement among people with my reading of it, but I read C2 as applying to decisions to take down speech from the internet. And as the text lays out, in my view, it imposes a higher bar on decisions to remove content than it does to leave content up. C1 says, if you leave content up there, you're not liable, the speaker is. In my view, again, some disagree with me, C2 says if you're going to take speech down, then you need to do so based on these enumerated categories that Congress put out there. You have a good faith belief that it falls within those enumerated categories. I think court cases have made a couple errors. One, they don't reach the C2 question. They sort of read C1 expansively. Again, some people would say they do that correctly. I don't take that view, but that's okay. So I think they need to reach C2 more often, read that it applies to takedown decisions. And I think we need to sort of read C2 the way Congress wrote it, which is imposing a higher bar for takedowns. Now, none of that is to say that that is an obligation to carry speech. You can always take down speech either with your 230C2 rights, or you can take down speech outside of 230 entirely, the way it's done in every other context, and do so based on your First Amendment rights. So my view is, let's leave in place this idea that if you don't censor, if you leave speech up, you aren't liable for that speech. That creates a regime in which we're going to see more speech, and revisit C2 so that if you're going to take down speech and maintain these 230 protections, you need to be held to the higher standard that is, in my view, actually in C2. But again, you can say, forget it. I don't want the 230 protections. I'm going to, take it down based on my First Amendment rights. And, I believe the First Amendment is a robust protection for everybody. In fact, we don't have, 230 that protections apply that in other contexts. We believe the First Amendment is robust enough to provide protections alone. So that's my view on the path forward. I also think that we should be promoting more transparency, which I've talked about. I think there's a role for the FCC there. I think there's a role for the Federal Trade Commission as well to hold these platforms accountable to their terms of service. If where we are right now is that a website can say, I reserve the right to do anything to anybody for any reason, well, what's the point in having sort of terms of service law? What's the point in having sort of, unfair or deceptive business practices? So I think the Federal Trade Commission should step up to the plate in terms of, holding these entities more accountable to sort of clear terms of service.
At our event last Friday, again, with the two FTC commissioners, and they were addressing this issue, and Commissioner Christine Wilson did indicate on her part receptivity to doing more regarding enforcing terms of service to ensure accountability to the actual stated terms of service. And I think maybe Commissioner Phillips did as well. I just, again, I see we have one good question in the chat line. If we have any others, put them up, and we'll do them quickly. But there's a lot of bills that have been introduced on the Hill. I think just recently, Senators Thune and Schatz reintroduced, I think, a bill that they had introduced before to revise 230. And I read a reaction from, let's see, what's his name? Jeff Kosef, who's the gentleman that wrote the book, 26 Words That Created the Internet. But he was quoted as saying that the senator's bill would effectively erase that precedent, referring to a liability precedent from the courts, and allow platforms to be liable if they know or have reason to know of the defamatory or other illegal content. Now, he was referring this specifically to illegal content, not generally moderation practices relating to, political discussion. But, it is the current law seems to be essentially that even if you know or have reason to know that the content is illegal, that you're essentially immune now. Anyway, I always appreciate hearing your views on that subject, and I hope you'll, I know you'll continue to think about it going forward. So I want to pose this question. I thought it is a good one. It's something that you haven't touched on. The question is, could you speak to the potential of satellite broadband in closing the digital divide?
Yeah, I am hopeful and optimistic, though cautious. We've got this new generation of low Earth orbit satellites that are going up that, for the first time are really providing speeds and latency that, before you needed a really good terrestrial connection to get, perhaps even sort of a fiber-like connection to get. And so particularly from a public policy perspective, when you look at how do we close that last, 1, 2, 3% of the digital divide, I think that there could be a very, very beneficial role for satellite providers. Now, that may or may not be their business model. And in fact, that's one of the reasons why, I think it's good that we got some commitments through the RDOF process to actually serve some of these more difficult to serve areas. So I am hopeful and optimistic. I think we need to give it a real fair shot of succeeding, but I'm not ready to put all the eggs in the basket there. I still think obviously we need, other technologies, a tech neutral approach, and it's not going to be a solution for everywhere, but I do think it could be a very powerful and efficient tool from a public policy perspective to close that, last percentage. Because again, when you look at, going 98% of the way, can cost X, and going the last 2% of the way can cost 2X. So I think that's a particular area where I would love to see, low Earth orbit satellites continue to play a role.
Okay, well, I'm going to pose a final question before we thank you and say goodbye. It's a topic that's on everyone's mind now, and that's universal service reform. And the contribution factor, as you know, Commissioner Carr, has now reached 33%. That's the tax on or the surcharge, as the FCC puts it on your telephone bills. I've got a nice chart that I have that I keep in my drawer that shows the increase over the years from back when it was 5-6%. Now it's 33%. So it does raise the question: how long can this go on in the current form? Do you have thoughts on reforming? I'm going to use the word reform the universal service system to get us to a better place, consistent with furthering broadband deployment aims and more ubiquitous service available to all.
When I was a baby lawyer, the very first project I had on the very first day that I started a law firm to research the trend lines in the USF contribution factor. This is back when I had hair on the top of my head and something other than white hair all along my face. And back then, to your point, it was like 5 going to 6%. And people were saying, if it ever goes to 8%, or if it ever crosses 10%, it's over. The whole regime will collapse. Well, it actually moved up steadily, but not rapidly, for a number of years. In the last couple, we've just seen a spiraling of the number. And to your point, now we're at 33, 34, somewhere in that range. The problem is, multifold. The one that I focus the most on is the more that percentage goes up, the more the bill for the average consumer goes up. And that means we're losing people, what I call sort of out the bottom, which means every month now, service is going to be too expensive for some set of Americans. And that is something that we just can't afford. So I do think this is something that, because of the spiraling we've seen recently, we need to take head on. One way we need to do that is, as we look at all these billions of dollars that Congress has given the FCC to spend outside of USF, so it doesn't go into the contribution base, we should look at how do we do this in a way that is going to reduce burdens on that USF contribution base. And one of the way we do that is by doing what we should be doing anyways, which is avoiding overbuilding. So if we can look at how do we sort of take these new dollars and not put them on top of existing dollars, maybe we can find a path where we could actually bring that number down. But I do think it's going to take some robust discussion here at the FCC and potentially in Congress as well to get to a long-term solution there.
Well, I'm going to wish you well in that robust discussion, but it's an important issue. Commissioner Carr, I just want to thank you. And I want to say we always enjoy having you on and with us. And I think every time we do have that opportunity, I know I'll learn something new and sometimes many new things. And we look forward the next time, hopefully when we're together again, we'll actually be able to reach out and touch each other and give each other at least a good elbow bump. I hope that's the case. But we covered a lot of ground, and we're grateful that you were with us today. Your continued leadership on some of the issues that we discussed today, to my mind, is very, very important. So I know that we'll be following closely what you do. So thanks again. I know Seth joins me in thanking you until next time.
Well, thank you. Thank you to you, Randy. Thank you to Seth and the whole team. Appreciate it.
Okay, we're going to say goodbye until the next time. Thanks.
Thank you.